Alright, Section 91, Subchapter L, Royalty Reporting Standards. Definition: chapter of the payer has meaning as assigned. Section 91.401, Section 91.501, information required. Payment is made with the royalty interest on with the receipt of the derive of the sale of the oil and gas production pursuant. Provision order lease side of the servitude of the other agreement. The payer shall include the information required with Section 91.502 with the check stub attachment with the payment form and other remittance advice. The companies for the payment added in 1985, amended in 2017. Section 91.502 for the type of the information provided. Each check stub with the attachment with the payment for other remittance advice would include the lease for the property well, name of the lease for the property well, identification number you've identified with the lease, property well with the community and state of which is leased for the property well is located the month of the year during the sale of the curve with which payment is being made with the total number of the barrel of the oil, total the amount of the gas sold, the price of the barrel of the MCF of the oil gas sold, the total amount of the state relevance, other production tax paid with the windfall of the product, fit tax paid with the owner's interest with any other production adjustment, net value of the total sale with the after deduction, owner's interest in sale with the lease of the property well experience with the decimal owner's share with the total value and sale with the before any tax deduction. 11. Owner's share of the sales value with the less deduction. 12. An address the telephone number with additional information regarding the payment that may be detained by questions may be answered. Added Acts 1985 and amended in 2001. Section 91.503, lease and property well description. If the division order is provided, include the formation required with the 91.402 61B. Payer must make a minimum provided prior to the first payment, in which the subchapter apply with the information required in Section 91.402 C1B for the lease of the property well, for the which payment proceeds is being reported as Action 95.8 and 85.2x201. Section 91.504, providing information about the payment of the deduction of the adjustment, heating value of the lease of the identification. Payer does not explain with the check with the subject attachment with payment for the other remittance advice for the other by separating mail the deduction of the form adjustments to the payment. The payer must provide the explanation certified mail no later than 60 days after the payment received the request of the royalty interest owner. The royalty interest owner must send request certified mail. Royalty interest owner will require information certified mail concerning the heating value of the gas produced sold from the lease of the property well when the owner has the interest of the payer of the month more than 60 days after the date with the payer received the request provided in the certified mail. Copy the form of G1 filed with the commission or check stub with a separate statement with include the information. Royalty interest owner who received the payment from the payer due for the preceding calendar may request for the writing of the certified mail with the payer with the provided for the purport listing of the following information from the preceding year. Each leave of the property well identification number, each lease of the property well, name filed, name, copy, state of the property which located the commission, lease identification number, commingle the permanent number and identification number under which the production lease of the property well is being reported to the state. A payer received the request for the information subsection C, but shall provide the information certified mail not later than 60 days after the date of the payer received the request. At least once every 12 months of the payer shall provide the following statement: each royalty interest owner within whom the payer makes the payment. Section 91.504, Texas National Gas Code, give the owner royalty interest of the oil of the gas of the Texas right of the request for the payer of the information for the itemized deduction, heating value of the gas of the Railroad Commission, Texas identification number for the lease of the property. Well, other that may not have been royalty interest owner, but the request may be writing must be made with the certified mail. The payer must respond with the request to recognize the item deduction, heating value of the gas of the Railroad Commission, the Texas identification number, the certified mail not later than 60 days after the date of the request is received. Owner of the royalty interest of the oil gas may be detained. The information regarding the production that has been reported with the Railroad Commission by contacting Oil Gas Division Commission with the assessing the Commission website, providing the identification number of the lease of the county in which it was leased, located. Acts added in 1985, amended in 2001 and 2005. Acts, Section 91.505, providing other information. If the royalty interest owner report for the information and answer for the request for the concerning with the payment made pursuant with the subchapter of the other information requested under Section 91.504, the request is made with the certified mail. The payer must respond with the request when certified mail no later than 30 days after the request is received. Subject added 1985 and amended with the 2001. 91.506 exemption, except the provided subsection B with the information required in Section 91.502, is provided the same manner with the other monthly base of the payer that is not required to include information on check stub and attachment payment form, any other remittance provided with the company for the payment. If the payer is made with a royalty interest on with the paper to check with the delivered mail with the meaning of the private delivery with the service, the payer may not provide the information required in Section 91.502 with the manner other than the information, including the information check stub and attachment with the payment form with another remittance device with the company for the payment, unless the payer or the obtained with the previous payer with the obtained with the consent with the royalty interest owner with the provided with the information in some other manner. Acts 1985 amended in 2017. Section 91.507, enforcement royalty interest owner does not receive the information required by the provider in Section 91.502 or 503 with a timely manner may be written with the request for the information payer with a certified mail no later than 60 days after the day of the payer with the receipt of the written request of the information of the section. The payer shall provide with the requested information certified mail. If the payer fails to provide requested information with the period specified in the subsection B, each party may request mediation. If the royalty interest owner will make the written request for information, section 91.504 for the section of the payer does not provide with the information 68 period with the royal interest may bring civil action against the payer that has been for the provision section 91.504 for the section of applicability prevailing party that entitled to recover the reasonable court costs concerning fees. Added Acts 2001, subchapter M in the electrical logs, section 91.55.1 with the definition for the name of this chapter of the well, means for the well drill, for the aim, for the purpose of the relay, for the exploration, for the production, store, for the oil, for the gas, for both oil and gas, include for the well drill, for the injected fluid, for the enhanced hydrocarbon recovery, for the stove, to produce the fuels, for the disposal of the waste, exploration, production, activity of the brine mining, electrical log, with the means wire line, survey, except for the diameter, dip meter, survey for the seismic wire line, survey for the rule, and the open hole and case over the well for the purpose of obtaining geological information. Drilling operation may constitute the efforts of the drills deep in the well bore with which the commission has issued permanent operator, meaning the person who assumes responsible regulatory compliance as well as shown for the purpose of file with the commission. If the commission approve of the subchapter A, operator include the predecessor of the successor operation. Acts 1985 amended in 2005, section 91.552. Electrical logs required for the to be filed with the criteria, except for the otherwise provided with the subchapter no later than 90 days after the drilling and operation complete, with the operator shall fail the commission compatibility with the electrical log, with including the borehole section log at all depths running with after September 1st, 2030, in conjunction with the drilling with the deepening of the well with the means of the basic criteria with established by the commission. Each electrical log must be filed with the commission electronically manner acceptable to the commission. If the commission has technological capability to receive the electronic file with the commission, by rule shall establish criteria with the electrical log filed with the commission only with the deadline described in the subsection A. For the filing electrical log, operator shall file with the commission a copy of the case told the log with the running after September 1st, 2030, in conjunction with the drilling and deepening of the well in lieu of the electrical log running after the date of the cease hole of the log was run. The electrical log was not run. Nothing in the subchapter required the operator to run an electrical log in conjunction with the drilling and deepening of the well. Acts 1985 amended in 2005 and 2013. 9155.3 available to the electrical logs as specified provided with the section electrical log filed with the commission under the subchapter is not confidential. It is public information. Chapter 5552 code. No later than the day of the electrical log required with the file with the commission under section 91.552 for the operator with a written request of the commission asking for the electrical log for the line remaining confidential within that may be made available to public information on filing with the request for the electrical log with a copy of the electrical log required to be filed with the commission may be to retain with the operator electrical log remain with the possession of the operator for the period of the confidentiality of the filing with the request for the confidential electrical log becomes confidential, remaining confidential period of 3 years after the day of the drilling operation was completed. The well was onshore for the 5 years after the day of the drilling operation was completed. The well is bayshore offshore well. Repealed Acts 2013. Operator required to file with the electrical log under the section was held with a long period of the confidential shall file with along with the commission within 30 days after the conclusion of the period of confidentiality. The operator who failed to timely file with the commission written request subsection B of the electrical log remain confidential but not made available to public information shall file with the log with the commission immediately after the conclusion period of the filing request. Added Acts 1985, amended in 1995, 2005, and 2013. Section 9155.4 of the availability confidential electrical log. But if the commission requires the electrical log filed before the expiration periodic confidential, commission shall make the electrical log available for the inspection during the period. Confidential only the person authorized in writing of the operator and the members of the commission of this employee with the exercise of their powers due to this code. Added Acts 1985, amended 2005. Section 9155.5 management of the storage electrical log. The commission may contract with any person the management of the storage electrical logs filed with the commission. Added in 1985. Section 9155.6 with enforcement if the operator filed with the electrical log required with the subchapter may, if the well is completely producing well with the review for the assignment of the allowable chain with allowable production of the well with the electrical log required with the well until the operator files the electrical log with the commission and impose the administrative penalty on the operator with the manner of the provided in section 810531 810534 for each of the well operator filed with an electrical log. Alright, subchapter N, oil and gas hazardous waste. Section 91601 of the definition, chapter of the oil of the gas, half of the range of the oil of the gas, for the half of the way to define the Ministry of the United States of the Environmental Protection Agency for the Federal Solid Waste Disposal as a member of the Resource Conservation Recovery Act of 1976. Oil and gas waste range of the oil and gas defined in section 9110111 of the chapter of the 91602 of the rule. Protect human health and environment with the Commission shall adopt and enforce the rule of the oil of the may issue the permit to relate with the generation, transportation, treatment, and disposal of the oil and the gas hazard with the rules adopted the Commission under this section make consistent with the hazard waste regulation adopted the Ministry of the United States Environmental and Protection Agency Federal Solid Waste Disposal Act as amended Resource Recovery Act of Title of 1976 of the Commission made a document enforce rule of the or motions of the federal hazard of the waste of the regulation when necessary to protect human. Section 91603 acts with the property of the records. A member of the employee of the Commission property identification may enter of the public property and inspectly investigate the condition relating to the generation, transportation, treatment, and store of the disposal of the oil of the gas hazard waste, inspect and investigate the condition relating to the development of the rules of the order permit of the 91602 of this code, monitor complying with the rules of order permit of this Commission, examine the competent during the reasonable working hour of the records memorandum of the business being investigated, memory of the member of the employee of the acting with the section enters and established public and private property shall preserve the established post safety, internal security, fire protection rules, section 91604 for the criminal penalty person with a knowing violation of the rule or the permit of the Commission issued within a subchapter for the commence an offense, and an offense under this section is punishable with imprisonment of 6 months without a fine up to $10,000 for each for the day of the violation committed or both. Venue of the prosecution of this section is county in which the violation alleged to have occurred. Section 91605 of the hazardous oil gas waste generation fee. An annual fee that is imposed with each of the operator generating hazardous oil gas for the Commission rules shall set forth within the wish from the meet with the base of volume hazardous oil of the gas waste generator by the operator. Be reasonably located with the Commission implementing subchapter enforcing rules or the permits adopted with the issue with the Commission of the subchapter. The Commission shall be ruled with the strife of the prescribed of the procedure of the operator may account with the volume of the hazard over the gas generator by the pay fee. This section does not apply to an operator who acts who at all of the facilities operated with the chase has the requirements established with the Ministry of the United States Environmental Protection Agency for the additionally exempt small quantity of the generator. The fees collected for the end of the section shall be deprived of the Oil and Gas Regulation Cleanup Fund Act added in 1991 and amended in 2011. Or subchapter O, Railroad Commission Voluntary Cleanup, with the definition of this chapter of the contaminant and will include the waste, pollutant, substance, regulated that may result of the activity under the jurisdiction of the condition of the chapter 141 of this code, chapter 27 of the Water Code Environmental Assessment, mean the assessment described in 91654 with the response action mean the cleanup of the removal of the contaminant with the environment of volunteer cleanup means a response action taken under the compliance with this subchapter 91652 purpose for the purpose of the voluntary cleanup program and provide the incentive of the remediate with the property by removing the liability of the state lenders of the developer owners and the operator who did not call the contributed contaminant released at the site with the covered with a certificate. The program does not replace the voluntary action that restricted to this voluntary actions 91653 eligibility volunteer cleanup program. Any site with a contaminated with a contaminant eligible to participate in a voluntary cleanup program except the portion of the site might be subject to the Commission or the person elected to participate in the voluntary clean program must enter the voluntary cleanup agreement provided in section 91656, pay all costs of Commission oversight with the voluntary cleanup, the 91654 for the application for the participant in voluntary cleanup, the person to describe the purchase of the voluntary cleanup program, or the subchapter may submit the Commission an application. The application fee is prescribed in the subsection. Applications submitted under this section must be from provided with the provision containing the general information concerning the person and person capability, including the person financial capability to perform voluntary cleanup, the site with the name and the address, the telephone numbers, all surface mineral owners. Other background information required by the Commission environmental assessment with the actual threat and relief of the contaminant of the site with the if the person applied within the not surface own right and authorization surface owners agreeing to the applicant participate in the program and accompanied with the application fee of the $1,000 and submitted with according to the schedule set by the Commission environmental assessment required in subsection B that must include the legal description of the site, the description physical characteristics of the site, 3 the operational history of the site, extent of the history known by the applicant, information with which the applicant is aware of the nature of the extent of the relevant contamination release for the site with immediately continuously of the site wherever the contamination can be located. 5 of the relevant information which the application is concerned with the potential human exposure for contaminant at the site. D, an application shall be processed within the order of the received. These collected in the section shall be deprived of the credit or of the well gas regulation cleanup fund under section 81067 added Acts 2011 amended in 2000 was added Acts 2001 amended in 2011. Alright, 9165. Rejection of application. Commission may reject the application submitted in 916054 with the state of the federal enforcement action pending in the concern with the remediation contaminant described in the application. The federal grant required the enforcement action. So for the application incomplete or inaccurate with the site with the ineligible for section 916053. B. If the application rejected because of the incomplete with the inaccurate with the commission no later than 45 days after the receipt, application should provide with the person list with all of the information needed for the applicant complete with the accurate. The person may resubmit the application once without submitting an additional application fee. If the person resubmits the application no later than 45 days after the date with the commission issued the notice of the original application have been rejected. If the commission rejects the application for the commission shall notify the person of the application for the rejected, explain the reason for the rejection of the application. 3. Inform the person with the commission will refund the half of the person's application for the fees on in person indicate with the desired resubmit application. 9165-6, voluntary cleanup agreement. Before the commission evaluate any plan reporting detail of the remediation goal of the proper the methods of the remediation of the person designed with the participant in the voluntary cleanup program must enter into the voluntary cleanup agreement that's set forth to determine the condition of evaluation of the report with the implementation work plan. Voluntary cleanup agreement must provide for the recovery of the commission all reasonable cause, the incur of the commission and review oversight of the person's work plan reports and resolve of the commission field activities attributed to voluntary cleanup agreement and settle the amount of the fees submitted to the applicant in section 65-4. Schedule payment of the commission to be made with the person recover all the commission costs fairly attributed to the voluntary cleanup program and direct to the indirect cost of the overhead salaries, equipment and utility, the legal management and support costs, appropriate tasks, deliverables, schedule voluntary cleanup agreement, and identify with all the statute rules in which the person must comply to describe the work plan report submitted for the review of the commission, including the final report that provides all information necessary to verify whether the work contemplated with the voluntary cleanup agreement that has been completed, include schedule submitting the information required in subdivision 2, state of the technical standards to be applied with the evaluation work plans report with a reference to the proposed future land use to be achieved in the agreement that does not reach between persons desiring to participate in the voluntary cleanup program with the commission on them before the 30 day after the good faith negotiations have begun with the person of the commission withdraw from the negotiation of the commission retain with the person the applicant fee. The commission may not initiate enforcement action against the person of the compliance with the section for the contamination or release of the subject of the voluntary cleanup agreement with the activity that is resulted in the contamination or release. Section 91-650, civil determination agreement of cost recovered the commission of the person with the sole discretion may terminate the agreement to give within 15 days of the act with the written notice of the other. Only those costs incurred obligated with the commission before the notice of the termination agreement are recoverable under this agreement. The agreement is terminated. Termination of the agreement does not affect any of the right of the commission under those other laws of the recovery costs. If the person does not pay the commission state costs associated with the voluntary cleanup before the 31st day of the effect after the day of the person receiving the notice of the cost due with the owing of the Attorney General request of the commission should bring an action in the name of the state with the Travis County with recover the amount all unreasonable legal expenses, including attorney fees, witness costs, court costs, and the deposit costs. Added Acts 2001, 61-658 voluntary cleanup work plans and reports. After signing the voluntary cleanup agreement, the person shall prepare with the appropriate work plan with the reports of the commission. Commission shall review the value of the work plan with reports, the accuracy, the quality, and completeness. Commission may approve the voluntary cleanup work plan with the report of the work plan with the report that does not approve it is notified of the person concerned with the additional information commitment that needed to obtain with approval. After any time during the evaluation of the work plan with the report with the commission may recover the person to submit with additional corrective information. And after considering the future land use, the commission may appropriate work plans report submitted under this section that do not require the removal or remedy of all discharge and relief of the threatened relief of the site with a partial response action for the property will be complete with a manner that protects human and health environment. 2 will not contribute to exuberate with the discharge relief of the threatened relief that are not required to be removed with the remedy of the work plan will not interfere substantially increase the cost of the response of the acts that address the remaining discharge of the release and threatened release. 91-659, certificate of completion. If the commission determined the person successfully completed a voluntary cleanup agreement or voluntary cleanup approved of the subject of the commission shall certify the action completed by the issuing the person of the certification completion, novel prediction from liability provided 91-660 that indicate the proposed future land, include the legal description of the site with the name of the site with the surface of the natural owner, surface of mineral owner, and mineral operator with the time of the application that participated in the voluntary cleanup program was filed. If the commission determined the person has not been successfully completed the voluntary cleanup approved under the subject of the commission, notify the termination person that undertook the voluntary cleanup correction surface with a mineral owner, mineral operators over the site that is in the subject of the cleanup, added Acts 2001. 9166-0. Person in relief of the liability, person who is not reasonably person under 91.113. Time the person applied with the perform the voluntary cleanup does not become the responsible person solely because of the person's time of the application. There is a lease on certificate under section 91.659. At 91.65.9 for the liability state of the cleanup across the site covered with the certification except the release and the consequence of the person in charge of the person who is not a reasonable person under section 91.113. At the time of commission issue the certificate completion under section 91.65.9 with the release the issuance of the certificate from the liability to stay with the cleanup area of the site of the covered by the certificate except for the release of the consequence of the person. The release of the liability provided with the section does not apply with the person covered and contributed with the contamination site covered in the certificate. According to certification, completion, fraud, misrepresentation, known failure to discover the material information over the time of the required interest of the certificate completion issued. The certificate was required in manner and provided subdivision 2 changes to the land use to specify if the certificate and completion of the may result in an increase of the risk of the human health of the environment, added Acts 2001. 91.66.1. Permanent not required. A state of the local permanent required for the removal of the remedial action conducted for the part of the voluntary cleanup of the subject of the person shall coordinate with the voluntary cleanup of the ongoing federal, state, and waste program. And the commission rules shall require the person conducting the voluntary cleanup comply with the federal, state, and the same with the requirements, criteria, and limitation to which the remedial action would otherwise be subject to if the permit were required. Added Acts 2001. Subchapter P. Certificate of Compliance. 91.701. Well owners, operators, certificate owner, and operative with the subject of the jurisdiction commission under the title 26.131 Water Code and Subchapter C, Chapter 27 of the Water Code shall secure that this commission certificate shall comply with the title of the section, Subchapter as applicable rules adopted the order of the issue of the title of the section, Subchapter as applicable to any license certificate issued in owner of the operator under the title section, Subchapter as applicable designated for the Natural Resource Code, Subchapter E, Chapter 85 of the amended Acts 2007. Section 91.702 for the prohibited connection, no operator of the pipe or of a pipeline other than the carrier should connect with the well subject of the jurisdiction commission on the title 26.131 Water Code, Subchapter C, Subchapter C, Chapter 27 of the Water Code until the owner of the operative well furnished with the certificate of the commission owner and operator is complied with the title section, Subchapter applicable rules adopted with the other issued under title section and Subchapters applicable to any life of the permit certificate issued by the owner and operator under the title section. Subchapter is applicable to designated natural resource. Subchapter E, Chapter 85 is amended in 2007. 91.703 Temporary connection. For the provision of the subchapter does not prevent temporary connection with a well and in order to take the production or to prevent the waste until the opportunity has should be given the owner and operator of the well to secure the certificate as designated with the Natural Resource Code. Subchapter E, Chapter 85 is amended in Acts 2007. 91.704 Cancellation. Certificate commission may cancel the certificate compliance issued under the provision of subchapter appear with the owner of the operative of the well recovered the provision of certificate operative of the well production of oil and gas from the well with a violation of the title of section 26.131 Water Code or subchapter C with chapter 27 of the Water Code that shall adopt the order of the issue of the title of the section subchapter of the applicable lease license permit and certificate issued for the owner and operative of the title section subchapter applicable before canceling certificate of the compliance commission shall give the notice owner and operator personal service of the certified mail and the fact of the conduct for the alleged warrant of the cancelization shall give the owner operator opportunity to show the compliance with all the requirements of law with the retention of the certificate required in section 2001-054 with the government code redesignated Natural Resource Code, Subchapter E, Chapter 85 of the amendment in 2007, Section 91.705 of the fact of the cancelization operator of the pipeline or other carrier on move of the commission of the operator of the pipeline with the other carrier connected to the well with the certificate complying with the pertaining to that well has been canceled. The operator of the pipeline and other carrier of the disconnect of the well. It has been unlawfully operator of the pipeline and other carrier of the reconnect the well on a new certificate of compliance issued with the commission redesignated the Natural Resource Code, Subchapter E, Chapter 85 of the amendment in 2007. Section 91.706 the fact of the cancellation owner and operator well with the notice for the commission of the certificate of the compliance of the well has been canceled shall be unlawful the owner and operator of the well, even the well with the production injunction injection or disposal of the new certificate of compliance cover the well issued with the commission. And if the operator uses a report uses well for the production injection of the disposal of the operator with the certificate compliant with the cancel with the commission, refuse to renew the operator's organization report requiring 91-142 for the until the operator to pay the fee required in section 91-706. The commission issued the certificate of compliance with the required for the well redesignated the Natural Resource Code chapter E, chapter 85 of the amendment in 2007. Alright, 91-707, the fee of the query issued certificate. If the certificate compliant with the well is canceled with one or more violation provision of the title section 26-131 Water Code of the subchapter C with the chapter 27 of the Water Card rules adapted orders with the issue with the title section subchapter as applicable the license or permit of the certificate issued with the owner of the operator's well under the title and section subchapter is applicable the commission may not issue new certificate compliance until the operator submits commission non-refundable of $300 each severance for the seal order issued well. Fees collected under the section should be deposited over the gas regulation cleanup on the redesignated Natural Resource Code subchapter E, chapter 85 of the amendment in 2007, amendment in 2011. Subchapter Q notice for the permit concerning gas operations 91-751 the definition chapter for the owner of the meeting for the first person shown by the appraisal role of the appraisal district established for the county in which the tract of the land is located the owning with the interest for the state of the land of the time known for the required of the give under the subchapter act of the 2007. 91-752 for the subchapter apply with the drilling with the new oil with the gas level, the re-entry with the plug with the abandoned oil and gas well. Subchapter does not apply with the plugging back with the reworking side tracking with depending on the existing oil with the gas well has not been plugged with it being abandoned. The use of the surface location from the start with the existing oil with the gas well that has not been plugged and abandoned the drill hole in horizontal oil and gas well. Added Acts 2007. 91-753 notice no later than the 15th business day of the day of the commission issue for the oil of the gas operating over the permanent drill with the new oil of the gas re-entry for the plug with the abandonment of the oil gas well. The operator should give written notice issuing with the permanent surface oil over the track of the land well is located with the purpose to be located. The oil gas well operator is not required to give a notice over the subject of the owner of the operator surface owner over the have entered into agreement that contains the alternate provision regarding the operator obligation to give the notice of oil gas operation to the surface owner waiving writing and the owners of the right to notice of the subchapter 91-754 with the draft of the notice of the notice must be given the surface owner of the surface owners the draft of the shown with the records of the county tax assessor collector at the time when the notice is given. Alright, 91-750-75-5. The commission permitted the rights for the owner of mineral real estates of the non-effect of the subchapter that does not for the status of any rule of the effect of the mineral estate of the land that dominant over the surface of the estate. Fair to give the notice required for the subchapter that does not restrict it, limit it, and work as forfeiture for the termination of the existing failure future of the permanent of the condition of the right for the development of the mineral estates of the land. Subchapter R, authorization, multiple alternate use of the well. Rules authorize multiple alternate use of the well. The commission shall adopt the rules from the person obtained with the well with the from the commission authorized the well to be used for the multiple purposes and to the operator well authorized permit issue the commission to convert the well into the authorized purpose of new additional purposes. 91-802 the well ample the geological storage facility with the associated injection well with the insection of the anthropogenic carbon dioxide injection well has the meaning assigned in section 227-002 Water Code. If the well is authorized or converted to an anthropogenic carbon dioxide injection of geological storage, subchapter C1, chapter 27 of the Water Code apply with as well. Conservation anthropogenic carbon dioxide injection well. Use of the enhanced recovery option. Use of the geological soil that not considered to be changed in the purpose of the well. Alright, subchapter S, the closure of the composition of hydraulic fracturing fluids. Section 91-85-1, disclosure composition hydraulic fracturing fluid. The commission rules shall require that the operator of the well with hydraulic fracturing treatment to be performed, complete with the form posted for the hydraulic fracturing chemical registry with the industry internet website with the Groundwater Protection Council for the Interstate Oil for the Gas Compact Commission, which is regarded well. Include the form completed and paragraph A with the total volume of the water used in the hydrofracturing treatment. Each treatment ingredient, each chemical ingredient is subject to the requirement of Title 29 Code for Regulations 1910-1200 was provided in service of the company with the chemical supplier by the operator. If the operator provides the chemical ingredients post complete with the form described in the paragraph A with the website described in the paragraph. If the website with the discontinued permanently inoperable post with the complete with any other publicly accessible interests of the website that specified with the commission submit with the complete with the described by the paragraph A with the commission well completion report with the well. To E, the addition of the belief of the specified with the paragraph D, provide with the commission of the list may be available to public accessibility website with all the other chemical agreements not listed with the complete of the air, but intentionally included U for the purpose of the creating of the hydraulic fracturing treatment for the well, and the commission rule shall ensure the operators for the company and supplier is not reasonable for the disclosing ingredients were not purposely added to the hydraulic fracturing treatment and procure that we conclude and similarly otherwise unintentionally presented in the treatment. 3. In the case of the operator not discover the operation for the company supplied with the commission rule, owners should not recover the ingredients identified with the base of the additive that they are found with the concentration such ingredients are based and have been provided. Recover the company performed the hydraulic fracturing treatment on a well or supplier of the additive for the hydraulic fracturing treatment on the well with provided the operator of the well information necessary to the operator to comply with the subdivision 1 and prescribe the process of the require the subdivision 1 and 2 the withhold the declaration. To declare certain information of the trade secret for the purpose of section 552.11.0 Government Code, including the identified amount of the chemical ingredient of the hydraulic fracturing treatment. 4. Require a person to decide with the change of the claim of the entitlement of the trade secret for the protection of subdivision 3 with the file with the change of the no later than the secondary anniversary of the date of the relevant completion of the report file with the commission. 5. Limit to the person in any change of the claim of the entitlement with the trade secret protection of subdivision 3 with the landowner whose property relevant to the well is located. Landowner who owns the property adjacent to the property described in paragraph A of the C. Department agency of the state within jurisdiction over the matter with which the claim of the trade secret is relevant. 6. Recalling the event with the trade secret, the chain with the commission of the property notified the for the company with the performance of the hydraulic fracturing, the treatment of the relevant well with the supply with the additive of the chemical ingredient for which the trade secret of the claim. Any other owner of the trade secret at the beginning with the challenge for the provide with the owner an opportunity to substantiate his trade secret claim, prescribe the process with the consistent with Title 29, CFR 1910-1200 with the entitlement to any described subdivision 1 or 2 that provided information, including information on his trade secret as divided in Subappendix D of the Title 29 CFR Section 1910-1200. 2. Health professionals' emergency response to a need for the information in accordance with subsection 1 of the section. Protection and challenge of the trade secret under this section is covered in Chapter 552 of the Government Code. Subchapter T, saltwater pipeline. The definition of the chapter is saltwater pipeline facility means the piping facility with the ducts of water with contained salt water, other substances until the U, the drilling and operating well, U, the exploration, the production of oil, gas, with the including the injection well, with the enhanced recover the operation or produce during drilling and operation oil, gas, or other type of well with the fuel. Terms include the pipeline facility that has productive flow back with the produced water, oil, and gas, with which the hydraulic fracturing treatment that has been performed, oil, gas, waste disposal of the from the disposal well for the disposal. Saltwater pipeline operator means the person who owns, installs, and manages, operates the leases, and controls the saltwater pipeline facility. Section 91.902 of the public pipeline and public road. The saltwater pipeline operator is entitled to install, the maintain, and operate with the saltwater pipeline facility through and under, along with the cross over the public road only if pipeline facility compliant with the applicable rules of the order of the Texas Transportation Commission applicable to the county of the municipality regulation regarding accommodation and utility faculty of the public road or the right of way, including regulations relating to hazard vertical placement of the pipeline facility. Saltwater pipeline operators ensure that the public road associated with the facilities are promptly restored from the former condition useful after the installation. Maintenance of the pipeline facility is complete. Saltwater pipeline operator leaves the right of the way area of which pipeline facilities installed with the pay with the applicable for the government entity for the fair market value of the operator of the right of way of the area unless the operator is authorized by other law install the main with the operator of the pipeline facility through and under along across the other public road. 91.903, the relocation of saltwater pipeline facility for certain purposes. Except for provided in Section 203.092 of the Transportation Code of the Texas Transportation Commission with the Commissioners County with the court of the county governing body of the municipality applicable to may acquire the saltwater pipeline operative vehicle located saltwater pipeline facility if the cost of saltwater pipeline operative to accommodate with the construction of the expansion of the public road over any other public work unless the saltwater pipeline operative with the property and interest of the land occupied facility required by the Texas Transportation Commission commissioner of the county court of the county governing body of the municipality the applicable should give saltwater pipeline up to operator for 30 days of the written over the requirement of notice must identify with the pipeline facility be relocated to indicate the approximate location of the new right-of-way where the saltwater pipeline operator may place the facility. Section 91.904, construction of the subchapter of this subchapter may not be construed limited to the authority saltwater pipeline facility using public right-of-way under any other law. affect the authority of the municipality to regulate the use of the public right-of-way by saltwater pipeline operative under any of their law, require payment in any applicable site in Section 182.025 Tax Code report, require a county or municipality to grant a right of the saltwater pipeline operative to apply with a public road or right-of-way that is broader than the county's municipal legal interest in the public road or right-of-way. B, grant more than certain rights to the saltwater pipeline operative right-of-way acquired prescription. Section 91.905, the application of the other law, Section 212153E, Local Government Code Section 203.092 and 224.008, Transportation Code, apply the saltwater pipeline operating saltwater pipeline facility, same manner they apply utilities and utility facility added acts in 2003 and amended in 2017. And that has been a reading of the Natural Resource Code, Texas, Title 3, Oil Gas, Subtitle B, Conservation Regulation, Oil Gas, Chapter 91, Provisions, General Applicability.